Breaking tonight, the Supreme Court is giving Georgia, Pennsylvania, Michigan, and Wisconsin until 3 p.m. Thursday to respond to an election lawsuit filed today by the state of Texas. The suit arguing that those states violated the Constitution in the process of appointing presidential electors by unlawfully abrogating state election laws. We're also learning tonight that Louisiana is about to join that Texas case. Joining me now is John Eastman, Claremont Institute Senior Fellow, former Supreme Court law clerk, and constitutional scholar. John, for the lay people out there, tell us why this lawsuit is one that we should be especially all paying attention to, given the thing called original jurisdiction. Not to sound like geeks here, but take it away.
Yeah, no, but it's great inside baseball. Look, one of the things that most people don't know is, the Supreme Court normally is the appellate court of last resort. But in a couple of types of cases, they have original jurisdiction. And in one of those types of cases, it's original and exclusive. And that group are cases between two states. We didn't want states warring with each other, and they gave this power to settle disputes between the states to the Supreme Court exclusively. So Texas has named Pennsylvania, Georgia, Michigan, and Wisconsin for violating election law. Now, the underlying issue there is a terrific one for Supreme Court, because it doesn't turn on proof of the allegations of fraud and the Dominion machines and all these other things that are huge evidentiary matters. It turns on a very simple legal question. Did these states conduct an election in violation of their state law? Because Article 2 of the U.S. Constitution says that the body that has the sole authority to create the manner for choosing presidential electors is the legislature of the state. And they do that by their state statutes. And when the Pennsylvania Secretary of State ignores those state statutes, sends absentee ballots out contrary to those state statutes, doesn't do voter identification or signature checking contrary to those statutes, those violations of statutes that were designed to prevent fraud are enough to trigger the federal constitutional violation that Texas has alleged.
So now the briefing schedule is what it is. It's very expedited. Does that mean the case will definitely be heard by the court, or could they still kick it out?
They could still kick it out. The way original jurisdiction works, the court has claimed to have, even on state cases, some discretion on whether to take it or not. So Texas had to file a motion for leave to bring this original action, and that's what the defendant states have been asked to respond to.
What's your gut?
I think they said it so quickly because.
What's your gut? Will they take it?
My guts, they're going to take it. My guts are going to take it and look at it on the merits. This is an extremely important legal issue that the Supreme Court has already twice in our history said if election laws of the state are not followed, that violates the federal Constitution. They did that in Bush versus Gore, and they said that back in 1892 in a case called McPherson versus Blecker.
Well, John, this is fascinating. This is the case, I should say, that I've been waiting for, and I can't wait to see where it goes. John, thank you.